Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Maritime Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people.
Mayday, mayday. Hello, can you hear us? Can you hear us? Can you... Over. We are sinking. We are sinking.
Hello? This is the German Coast Guard.
We are sinking. We're sinking.
What are you thinking about?
Hey, good morning, good afternoon, good evening, good night, whoever you are, wherever you are, whatever you're doing. It's Maritime Monday. It's time to cut it out and focus. We are here, and we're going to be taking a little step back in time about a year ago to look at the new lawsuit that has just been filed in relation to the Titan submersible implosion just over a year ago. The family of the French explorer that was on board has filed a $50 million lawsuit against a bunch of people. And that's what we're going to be looking at today. But because it is Maritime Monday, you know what time it is. It's that time that you all need to understand one thing.
Look at me, sure. Look at me, sure. I'm the captain now.
Except for Yoda. Yoda is taking umbrage to that, I think. Yoda, you have sat here quietly the entire 4 hours I've been home from work, not making a peep. The second we go live, you got to have your little attack, don't you? You got to have your 2-minute struggle session. All right. We'll just have to put it with Yoda's little struggle session as long as he does. But anyway, all right. Let's quickly get through the housekeeping stuff because we have a lot of lawsuit to go through. It's 28 pages long, and all of it is very, very important for a multitude of reasons. And we're hopefully going to get to that today. We'll get through it all, I hope. Let's see. We currently have 202 people here in chat right now. That's a great start to the day. And only 104. We got 210 now and 104 likes. Come on, people. Half of you haven't done your job. 100 of you need to get down there and smash that like button while you're here yet. Don't cause Yoda more angst. Exactly, Yoda. Attack. Attack emotional support potato pig dog. Attack. Anyway, as always, the emotional support potato pig dog cam is locked and loaded and ready to go if we should unlock that particular achievement, if we should reach the goal. And we've got the other two goals lined up. the second goal and the third goal. We'll see how many goals we get through today. Not required, not expected, but always and graciously appreciated and humbly accepted are the super chats and memberships and et cetera, et cetera, et cetera. And we'll read them up we'll read the super chats and other things as they come up. Again, on these hard reading days where there's a lot of reading, I have a little bit less ability to follow what's going on in chat. So if there's something you need to ask, something you need to say, something you need a response to, the super chat, unfortunately, is the best way to do that. Because that gets my attention because it's all full of bright colors and it pops and I go, aha, there it is, and it's automatically starred as an important conversation. So that's the best way to do it. And like I said, if we get to the $100 mark through whatever means necessary, we unlock the emotional support potato pig dog cam and a punishment shot at the 200 and then a reward shot at the 300 level. So there we go. Right. Trying to think if there's anything else we need to really get out of the way. Tomorrow we'll be doing Sarah Boone, the Sarah Boone trial from last Friday, the hearing. Wednesday, not sure. Thursday, our retro trial, and Friday got a little something planned. We'll just have to see who's going to be on. It's the Unexplained. We'll have a special Unexplained show with Flux and maybe Danny. Danny's trying to work through some scheduling conflicts, but we will be having a ghost hunter / Bigfoot hunter / perhaps medium on the Unexplained show this coming Friday. Or is it Saturday? I can't remember. Yes, Friday evening. All right. All right. So that's it. That's all the background stuff we got to get. That's all the house cleaning stuff we got to do. You guys do your thing and I'll do my thing and we'll see how we are going. What? Little misses, are those suspenders? No, those are called stripes. Suspenders like continue around. Those are stripes on this lovely, lovely Cuban shirt I have on. Oh, there we go. Hey, Ron. Okay, come on, Straub. You cannot be shaking the camera like that. Come on, buddy. Come on, girl.
I know. I want you to lay under there, but you can't. You can't keep bumping the camera. Okay.
Oh my gosh, these dogs! I swear to God. All right, here we go. Let's try that. Let's try that awesome introduction again. Hey, Ron, with a $5 super chat. Let's get this perk started. Lego. It's $5 to get it started. Thank you very, very much. You have started it. And with that out of the way, let's give our little intermission and get on with the meat and bones of today's show, shall we? It's that time.
This is a brief intermission.
You're very much appreciated for saying that I'm appreciated. I appreciate that.
This is a brief intermission.
Thank you very, very much. I'm going to have a search and or seizure. More likely the seizure. I appreciate you.
This is a brief intermission.
I appreciate you. Okay, we are here to talk about the $50 million lawsuit that was filed by the administrator of the estate of Paul-Henri Louis-Émile Nargeolet. See, I'm French. Sorry to all you French people out there for my awesome French pronunciation, but that's as good as it gets. We're going to be reading through this lawsuit today. It's lengthy, it's 28 pages, but it is full of some very important information. Some of it new, some of it old, some of it speculative at best, but it's nonetheless very important. It's the first substantive lawsuit filed in regard to the implosion of the Titan submersible. And Jason J says, "Damn it, Legal Vices, you need X-Ray Girl on the Unexplained stream. In due course, we shall. Never fear." Okay, let's bring up, well, before we bring up the lawsuit. Let's bring up the lawsuit. Because I'm thinking out loud. Bear with me. Right, this is the lawsuit here. I've got to rearrange a couple of windows to make this more readable for me.
Here we go.
All right, if we go all the way to the end, we go all the way to the end of this 28-page lawsuit, we see that the lawyers involved in this are Matthew D. Schaefer and a bunch of other people from the Schechter, Schaefer, and Harris LLP. Now, who are these people? who Matthew Schaefer is a well-renowned maritime lawyer out of Houston, Texas. They're like New York and Houston are pretty much, and to a certain extent, Los Angeles, but New York, Houston, the Virginia area, they're sort of the center for maritime law in the States. I mean, Houston, one of the largest ports in the world, but Matthew Schaefer is he's well known. He was involved in the Deepwater Horizon explosion. He's been involved in some very, very high profile cases, and he has successful settled the largest single victim Jones Act, which we'll talk about in a minute. The single largest Jones Act victim case on record for a client with a brain injury. So they're good lawyers. They've hired good lawyers to represent them. And the Busby law firm, I don't know anything about the Busby law firm, but they are also based in Texas. See, here you go: Texas, New York, Texas, California, Texas, and Texas, Louisiana. Yeah, Louisiana, actually, they're because of Tulane. Tulane is the premier maritime law focused law school in the country. So these are the people that are involved in this particular lawsuit. They're the lawyers that have been hired by the family, or by the estate, I should say, not the family. Oh, I forgot to mention our like and subscribe poll. Gee, I should be ashamed of myself for not mentioning the like and subscribe poll. We've got 300 people here, 166 likes. Again, about 50% of you haven't done your job. 130 of you need to get on over there and hit that like and subscribe button and take our like and subscribe poll. What's wrong with the OceanGate case? What's wrong with the OceanGate case? Lies and bad construction. It was a crushing failure. It was a titanic waste of life. And no cannibalism. Those are your choices. The like and subscribe poll means nothing other than a silly, stupid reminder for you to do that YouTube thing and hit the like and subscribe. We'll check back in an hour or so and see what your answers are to the like and subscribe poll. And all right, Miss K. Griffith, I see that you want the frog merch. We can do some frog merch, I guess. All right, we'll talk about that another time. But we that's something that can definitely be done. All right, this is the case. Now, there's a few things we need to discuss before we actually get into the case. Here we have Richard Ortoli as administrator, CTA of the estate of Paul-Henri Louis-Emile Nargeolet, deceased plaintiff. And Nargeolet was a very, very well-known French explorer. He was sort of Mr. Titanic. He was one of the world's foremost Titanic experts. And he was on that submersible when it went down, and he was with his son, I believe. So yeah, didn't make it, obviously. And they are suing, the estate is suing OceanGate Inc., the estate of R.S. Rush III. He was the owner of OceanGate and the creator of the Titan. Tony Nissen, we'll talk about who he is. Electro Impact Inc., Janicki Industries Inc., and Hydrospace Group Inc. as defendants. These, take off my watch here. Thank you. All right, these are, why did I say thank you for letting me take off my watch? So this case is filed under the Jones Act. 46 USC Statutes 30104 et sec, the General Maritime Law, and Washington State Law. So this is actually, this actually will be an admiralty court. Yay, sovereign citizens! This case will actually be heard in a real Washington State court. Will be functioning as an admiralty court. So bring all your soft set friends to the party, because they can see what a real admiralty court is. And Washington State law, and they have demanded a jury trial. Now, what is the Jones Act? Oh God, the Jones Act is a frightening piece of of statute.
It pretty much governs the affairs of seafarers. And chat, I'm going to use the word seaman a lot to refer to people who work on ships. So control yourself, okay? let's try to act at least 18 instead of our usual 12 and 13 years old. So because we're going to be talking a lot about seamen today. I don't even trust you guys. I'm going to try to say seafarer as much as I possibly can. All right. So the Jones Act. It's it's based on the Merchant Marine Act of 1920. And it's a law that protects and regulates the maritime shipping industry in the U.S. And it deals with cargo traveling between two ports. Now, see, this is an interesting thing. This is actually dealing with a case that I'm working on now. I mean, it's a contractual deal, trying to develop a contract to deal with things like this. If you haul cargo from one place in the U.S. to another place in the U.S., the Jones Act requires that cargo be carried on a United States owned, on an American owned ship that's been built in the United States and has a majority of United States citizens as crew. There's a lot of protections for seafarers, which is the main part we're going to look at today. The Jones Act is, I think past its prime. The Jones Act was passed, like I said, 1920, sort of in the aftermath of World War I to jumpstart the shipping economy, to bolster up the shipping industry at the time. It's very, very protectionist, but what it does now is it serves to make shipping incredibly expensive in the U.S., especially if you've ever gone to like Hawaii or Puerto Rico and you wonder why everything is so damn expensive there, you can pretty much blame the Jones Act because of the additional costs that are imposed on making sure that all aspects of the Jones Act are complied with when shipping supplies, food, and things like that between mainland U.S. and the islands of the U.S. So the Jones Act arguably is well past its prime and might not need to be there. So the one part of the Jones Act we're going to be looking at here is the part that deals with personal injury claims. And I'll have a few comments about it as we go along. Cheesehead lost on Bourbon Street, member for 23 months. How you doing? It's good to see you. Yay, made alive, kids back in school. I have a life again. Woohoo! What vices are we getting immersed in today? 9 hours before four-footers return and life implodes. Hopefully nothing will implode during the stream because that's all we're going to be talking about is implosions today. All right, thank you so much for being a supporting member for darn near 2 years. And Pin King 584, the $2. So the seamen are spread all over. Yes. I knew I could count on you guys to keep it classy. Thank you very much, Pin King 554. And Caldrak, who's been a member for 6 months. Greetings to months. Me read good. Greetings to Rear Admiral Jeff. Hope your days are long. Your whiskey. God, thank you. I forgot. Thank you very much. My whiskey cold and the case is easy. Cases are never easy, but yes, I do need to pour a refreshing glass. There's something really, really good about a good smoky Lafroig. This is Lafroig Select. A good peaty smoky. Lafroig is more smoky than peaty. It's a good smoky Lafroig that's been chilled Oh, it's so good. All right. Thank you very much for reminding me of that. I would have looked over there later and went, oh, disappointment. All right. So that's sort of setting the backdrop for this. We've got the basics of the Jones Act. We know who's involved on the lawyer's side and the other side. On the lawyer's side, on the plaintiff's side. Here's the plaintiff's original complaint. Let's see what we can do here. We may have to stretch this out a little bit. There we go. Oh, we've got the magic words. Comes now. Plaintiff Richard Ortoli. This is the magic words. This is the magic words you have to have at the beginning of every document you submit. I don't like the magic words, but they have to be said. Comes now, Plaintiff Richard Ortoli, plaintiff as administrator CTA of the estate of Paul-Henri Louis-Emile Nargeolet, deceased Nargeolet, and brings this action against defendants OceanGate Inc., the estate of R.S. Rush III, Tony Neeson Electro Impact Inc., Janicki Industries Inc., and Hydrospace Inc., collectively defendants for their wrongdoing detailed below. Whew. That was difficult to get out in one breath. All right, so that's the magic words we have to say to start the lawsuit. Introduction. Now, this is going to give us a little detail into the background of the case. We're going to go through the background facts to refresh your memory and to introduce a few new facts that you may know. Well, alleged introductory facts that you may not have known about. On June 18th, 2023, again, just over what? We're coming up on 14 months. In the waters of the North Atlantic, off the coast of Newfoundland, Paul-Henri Nargeolet and 5 other crew members boarded the manned deep-sea submersible Titan and began a descent towards the most famous shipwreck in history, the Titanic. Mere hours later, the world learned that Titan's surface support ship had lost contact with the submersible and waited with bated breath for further news of the crew's plight. Ultimately, everyone's worst fears were confirmed. The Titan had suffered a catastrophic implosion under the tremendous weight of the ocean's depths. All 5 crew members, including Nargeolet, died. Hey, Uncivil, what's up? Decedent Nargeolet was known to the world. No, this is what we talked about earlier. Was known worldwide as Mr. Titanic. That's what they called me, and it's not just because I'm fat. Actually, it is. It's just because I'm fat. Anyway, a charismatic and beloved adventurer and a legend in the diving community. Nargeolet had participated in 37 dives to the wreckage of the Titanic, the most of any diver worldwide. Over the course of his storied career, he was part of the first expedition to visit Titanic in 1987, shortly after its location was discovered. And we talked about the discovery of the Titanic during a couple of our previous Maritime Mondays, which basically they weren't looking for the Titanic. We were looking for 2 nuclear submarines that had sunk at various points in history. We knew where they were, and the Titanic was sort of between the two. We had a good idea where the Titanic was because it had been previously reported. But the idea was the government, it was a secret government mission to examine these 2 sunken submarines to see if they'd been visited by the Soviets or Russians, and if any of the if any of the nuclear warheads were missing, or if there was anything else to indicate that they'd been messed with. I almost said the F word. That they'd been messed with. And they said, while you're at it, wink, wink, we'll let you go look for the Titanic. So that's kind of how the Titanic was found. We sort of always knew where it was, but they were allowed to visit it if they would first do these 2 secret government missions, which they did. And Jeff Moser with the $2, I'd rather be in Titan than Boone's suitcase. Well, the ending was the same for both of them, so 6 of one, half a dozen of the other, I guess. So, anywho, I take slight umbrage with the term location of the Titanic being discovered because we really knew where it was. We just kind of hadn't been there. He was part of the first expedition to visit the Titanic in 1987, shortly after its location was discovered, and has supervised the salvage of innumerable Titanic artifacts. Nargeolet was the director of underwater research at RMS Titanic, which owns the salvage rights to the sunken ship. Now, the RMS Titanic, this company, that it's a U.S.-based salvage company that owns the rights to the Titanic, they're actually preparing to run a new mission to the Titanic. But again, not to really take anything from it, more to they previously digitally mapped it, 3D mapped it, but they're going down with much more sophisticated equipment to map out the outside and to the inside as much as they can of the Titanic, to preserve it, perhaps for holographic purposes later, because the Titanic is being destroyed. It's dissolving. There's a rare, interesting breed of metal-eating bacteria that has just covered the Titanic and is just eating the Titanic. So the Titanic is not destined to be around much longer. So they want to they want to make sure they get as much of it mapped out digitally in as high a quality as they possibly can. Nargeolet was the director of underwater research at RMS Titanic, which owns the salvage rights to the sunken ship. In the diving community, Paul-Henri Nargeolet, or PH, as he was often known, that's how we should refer to him, was synonymous with the Titanic. Decedent Nargeolet, or PH, as his friends called him, was also an employee of defendant OceanGate, Inc. Now, here's where we start to get a little bit interesting. A deep-sea diving and submersible company that designed and built Titan for the purpose of repeatedly voyaging to the Titanic. Decedent Nargeolet served as a crew member aboard the Titan. His job was to guide other crew members and assist with navigation through the Titanic wreckage, which he knew so well. Now, this was an interesting thing, something which I thought was very interesting. This was something that Stockton Rush did. Richard Stockton Rush. This is something that Stockton Rush did. He basically made everybody that was on the Titanic, on the Titan, a crew member. That may not have been the smartest thing for him to do, because it opens him up to what we're going to be looking at today, the infamous Jones Act. The Jones Act applies to seafarers. I'm not going to say the other S word because of you guys. We're not going to say the other C word, S word. We're not going to say the C word at all. We're not going to say the other S word. Unless you're Squid Pro Quo. Thank you, Squid member for 9 months. Jeff, you know what you did with the seaman comment. It's like telling people afraid of heights not to look down. Yep. All right. Hopefully that'll be the last time we hear that particular word today. All right. So this, I have to give a little bit of an explanation of the Jones Act here. Again, as it relates to this, we gave a say the line, Jeff. Say the line. Thank you so much on civil law. Say the line. Got to think of a funny reply, because I can't say the line that I know you want me to say, because it has nothing to do with this. Attached to this lawsuit is a new and interesting revelation of the Jones Act. No, actually, there's really no new revelations. It's the Jones Act. It's been basically the same forever. Now, the Jones Act, as it relates to personal injury, is essentially a workers' compensation thing, but you can't claim compensation under a state workers' compensation scheme and the Jones Act. It's got to be one or the other. And the state and federal law will dictate which you get to use. Now, why I say it was probably in retrospect a bad idea to make everyone on board the Titan submersible a crewman is because it triggers the Jones Act for workers' compensation, and that it covers things like compensation for medical bills, replacement income, compensation for permanent injuries, death, obviously, anything if you survive an accident, rehabilitation, and pain and suffering. So you got maintenance and cure, and you've got all kinds of pain and suffering stuff, which is kind of the problem here. That's where a lot of the $50 million comes in. Now, why I say it was a mistake is the compensation allowable under the Jones Act is much greater than it would be under a state workers' compensation case, by and large. The other thing, which I guess, like I said, we'll probably never know why he made them all crewmen. But under a normal workers' compensation act case, it doesn't matter how you got injured or killed. Just the workers' compensation is triggered and you get paid. Under the Jones Act, you have to prove that that your employer was negligent. I don't think we're going to have a problem. I don't think we're going to have a problem in that. It's sort of like the standard tort things. You have to prove that your employer was negligent. You have to prove, you have the burden of proving that the negligence caused the injury. Those are your basic deals. They owe you a duty of care. They breached the duty of care. And then that caused you damages. And as I was saying, like while you're limited to what you can get through workers' compensation claims, it doesn't matter who's responsible for your injuries. Whereas on the other side, the Jones Act claims, you get much more, and you just have to prove. But again, the other problem is under workers' compensation, if I'm like 98% responsible for my own death or my own serious injury, I still get paid the workers' compensation stuff. But let's say in a Jones Act case like this, if me as the claimant, if I am 90% responsible for my own injury or death, then that 90% is deducted from the overall compensation. It's a contributory liability, they call it. So my stupidity gets deducted from his stupidity. And so I would get a 10% of my claims, of my proven claims in that instance. So that's kind of the background. I don't know why they wouldn't just, why he wanted to make these people crewmen. I will never understand that, because it triggers this immense compensation under the Jones Act. But hey, it's already happened. It's over and done with, and there ain't no going back. So let's get back into the lawsuit here. I hope that the Jones Act is so ridiculously complicated, it's sort of like tax law, where any tax lawyer that says they understand all of tax law is just lying to you. Jones Act cases are cases that you pretty much have to research in detail each and every time, unless it's a basic principle. All right, so anyway, so he's now a crew member. They've hired him. Everyone on there is a crew member. So now we've triggered the Jones Act. OceanGate was founded by Richard Stockton Rush, an eccentric and self-styled innovator in the deep sea diving industry. As detailed herein, OceanGate, Rush, and the remaining defendants designed, constructed, and operated Titan in almost every way, in a manner outside the norms of the diving community and industry, driven by Rush's apparent obsession with being remembered for innovation alongside such luminaries as Steve Jobs and Elon Musk. Well, there you go. Been there, done that with the $5. What is long, hard, and full of semen? A submarine. Thank you very, very much. Been there, done that. Yay. I need some sort of button of shame for you and your jokes, people. All right. Let's continue. Thank you very much for that, by the way. Appreciate it. Decedent Nargeolet. We've bumped this thing off to the side again here. Let me slide this on over. There we go. Decedent Nargeolet may have died doing what he loved to do, but his death and the deaths of the other Titan crew members was wrongful. Wrongful death. There we go. There's some more magic legal words. The catastrophic implosion, the claim Nargeolet's life was due directly to the persistent carelessness, recklessness. Remember, you had to prove they're negligent. There you go. Carelessness and recklessness and negligence. They're kind of all various degrees of the same thing. Zelle says, ooh, speak more of that hot contributory versus comparative negligence. Yes, this is a contributory negligence case. Rower. Okay, so the carelessness, recklessness, and negligence, they're all kind of the same thing, but arguably differing degrees of the same thing. Negligence of OceanGate, Rush, and the other defendants in their design, construction, and operation of Titan. Moreover, OceanGate, Rush, and all the other defendants were warned repeatedly by multiple deep sea diving experts and engineers about the potentially fatal consequences of their choices and actions. Now, that's an interesting phrase. And the other defendants were warned repeatedly by multiple deep sea diving experts and engineers about the potentially fatal consequences of their choices and actions. Defendants did not heed those warnings. Now, I say that's an interesting phraseology because, as we'll see later, even in their own complaint, you'll be seeing that the decedent Nargeolet was also warned repeatedly of the potential consequences of getting on the Titan. And the decedent, the claimant himself, did not heed those warnings. So this is a little tricky, this wording here. It's I don't know if it rises to the level of irony, but there's a little bit of, pointing at me thing. It's a little bit like the Spider-Man meme, everybody pointing at each other and saying the same thing. Defendant did not heed those warnings, but rather appeared to have been increasingly motivated over time to ignore them. Worse, in many instances, Rush concealed dangers of which he was aware, specifically providing only certain information to his crew and the public at large. The warnings proved prescient. Decedent Nargeolet's death was a tragic but eminently preventable occurrence. Oh, here's the jurisdiction, the second only to governing law in its excitement in a lawsuit. This is an action within the maritime jurisdiction of this court. Again, bring all your sovereign citizen friends. I think this is I believe this is in, yes, King County. I was going to guess, but I didn't want to be wrong. King County, the district court, is going to be a real live admiralty court. So bring all your sovereign citizen friends so they can see what an admiralty court really does. And I'll guarantee you none of it they've ever seen or heard of or care about. Right. So this claim is maintained under the Jones Act, 46 U.S.C. Section 30104 et sec, and the General Maritime Law of the United States, and any other applicable laws that plaintiff will plead and prove. See, I don't like this. If we can, this is, and any other applicable law, it's like we don't know what laws apply just yet. That's sort of what that's saying. I think you should be required to say exactly what law applies to your claims without saying, we're filing this lawsuit and we'll figure out what laws apply later. I don't like this. Because how does the defense defend themselves on a legal basis if they don't know what laws are ultimately going to be claimed to govern the case later? I just don't like that wording. Plaintiff hereby exercises the right to pursue the claims asserted herein in the state court pursuant to the Savings to Suitors Clause. You don't need to worry about that, but it's a thing. In the alternative, plaintiff brings these claims against defendant under Washington state law for negligence, wrongful death, and products liability. So if for some reason you find the Jones Act doesn't apply, then we want it under state law. The parties, here's where we get introduced to people. Before we make our introductions to everybody, Hugh Jass, member for 14 months, has all the King Seahorses and all the King Seamen, ... Thank you very much for the ellipses. I appreciate that. You could have started those ellipses one word previously, but thank you very much for the support. And we are $85 away from unleashing the emotional support potato pig dog cam. All right, here's our parties. It's a party. Plaintiff Richard Ortoli is domiciled in Miami, Florida, and has been duly appointed. So we've got Texas lawyers, Florida people. Why are we in Washington? Well, we're going to find that out in the next little bit here. Plaintiff Richard Ortoli is domiciled in Miami, Florida, and has been duly appointed as the administrator CTA of the estate of Paul-Henri Louis-Emile Nargeolet by the Dutchess County Surrogate Court of the state of New York. Plaintiff Richard Ortoli maintains his suit for the benefit of the beneficiaries allowed to recover on the cause of action stemming from the death of decedent Nargeolet. Basically, he's representing the heirs. He's representing Nargeolet's heirs and the people that get to claim for his death. Defendant OceanGate Inc. is a domestic corporation doing business in the state of Washington, King County. That's why we are bringing this in the King County Court in the state of Washington, because that's where OceanGate lived. The defendant may be served with due process by serving as registered agent Fairchild Richard Search Ltd. In Tumwater, Washington. Now, see, this is a common thing, especially for. And I hate to say this, but you'll notice that there's a designated agent. There is somebody whose sole job is to receive legal filings against the company. And that's pretty typical of paper companies that don't have any assets and they only exist on a shelf in a lawyer's office. Usually the lawyer who incorporated the company and has the licensing documents will just be the agent to receive any lawsuits that someone has against the essentially non-existent company, or where a company gets sued so often that they just can't be bothered accepting all the court documents. So that's it's interesting that they have a registered service agent. Defendant, the estate of R.S. Rush III, he died too, so it's his estate. So they want to take money from R.S. Rush's heirs and give it to the heirs of Nargeolet. They're saying, hey, you guys thought you got a big windfall when dad, crazy dad, crazy grandpa, whatever died. We want to take your money and give it to this guy. Always an interesting thing. Decedent R.S. Rush III, Rush. Tom Sawyer. Insert Tom Sawyer jokes there. Like I just went through the entire Rush discography when they said that. All right. The decedent Rush died a resident of King County, Washington on June 18th, 2023. And the probate proceeding stemming from his death is pending in the Superior Court of Washington for King County. The defendant may be served with due process along with the personal representative of the estate of R.S. Rush III, which is the decedent's surviving spouse, Wendy Whale Rush, through her counsel of record in the probate proceeding, Laura L. Brown of the law offices of Laura L. Brown. Defendant Tony Nissen. Who is Tony Nissen and why is he being sued? He's a natural person. He's a traveler on the land. Now, Tony Nissen is a natural person of majority age and is the former director of engineering of OceanGate Inc. It sounds like they're going to say he was the one that designed the Titan. The defendant may be served due process at his residence or wherever he may be found. That process server is looking for you, Tony. Defendant Electro Impact Inc. is a domestic corporation doing business in the state of Washington with its principal office at Mukilteo, Washington. All right. The defendant may be served with due process by serving as registered agent Peter Zevi at this address. And defendant Janicki Industries Inc. is a domestic corporation doing business in the state of Washington with its principal office in Cedro Woolley, Washington. The defendant may be served with due process by serving as registered agent Peter W. Janicki at his address. And finally, deodorant hyperspace. Defendant damn it. Let's try this again, shall we? Defendant Hydrospace Group, Inc. is a foreign corporation doing business in the state of Washington with its principal office in Claremont, California. The defendant may be served with due process by serving its registered agent, William Conan, at this address. And I really wish I could get whatever is my eye out of it. Apologies here for just a second. All right. Whew, that was exciting, wasn't it? Those are the parties. Those are the people we're getting introduced to. They're the ones that are going to be named in this lawsuit as we move forward. ARCS with the $2. Wait, he drank a whole gallon, you say, at once. So the reports say, my friend. So the reports say. Mary Jane, not really Sarah, member for 4 months. Mike Hunt, love Baghdets. One day he came down with a fatal yeast infection. Sucks to be him, doesn't it? Damn it, chat. We're trying to be serious here. Venue. Ooh, we talked about forum. Let's talk some more about it. Let's do this. I said we talked about right up here. We talked about jurisdiction. So let's talk about venue. Sort of a spin-off of jurisdiction, if you will. Venue is proper in King County, Washington, under Washington Revised Code annotated 41225, because one or more of the defendants resides in King County, Washington, and or performs substantial business in King County, Washington. Mercifully short. I think they could have put that up with a jurisdiction clause, but hey, it's not really that important. Now, here's where we're going to get into the facts, the alleged facts. Some of these are known, some of these were new to me, and there's some of them that, quite frankly, are a bit speculative. That the plaintiffs are hoping are true, I think, and we'll highlight some of those. Fort Titan, it will hold this. People. Right, let's go. Plaintiff Richard Ortoli has been duly appointed as the administrator CTA of the estate of Paul-Henri. I thought they were going to call him decedent Nargeolet. They keep using his long French name. We'll just call him PH. By the Dutchess County Surrogate Court in the state of New York, plaintiff brings this lawsuit as a result of the death of PH aboard Titan on or about June 18th, 2023. At the time of his death, PH was a resident of Dutchess County, New York. Okay, we can call him decedent Nargeolet. Was survived by his spouse. Oh, I thought his son was on the. I thought his son was on it. Somebody's son was on it with him, weren't they? Decedent Nargeolet was survived by his spouse Anne, and his children Julian, Sydney, and Chloe. Prior to his death, decedent Nargeolet contributed both financial and non-economic support to his spouse and children. So again, this is the billionaire's son was on it with him. Okay, that's who it was. It was Rush's son that was on it with him. I knew somebody's son was there. Okay, so it was Rush's son. They were all rich. The tickets, or the price of admission was $250,000 a person. Anywho, prior to his death, decedent Nargeolet contributed both financial and non-economic support to his spouse and children. Yes, he provided for his family. Now he's dead, and there's no one that can provide for the family, so we need $50 million. That's where we're going with this. Plaintiff maintains this suit for the benefit of beneficiaries allowed to recover on a cause of action stemming from the death of decedent Nargeolet. On or about June 18th, 2023, employees and or agents of one or more named defendants negligently and recklessly caused the death of PH on board the Titan submersible, a vessel operating in navigable waters. If it actually is a vessel, and there's still some arguing about that, did it really qualify as a vessel or not? But assuming it does, it was operating in navigable waters. Rush, OceanGate, and the development of Titan. Now we're starting to peel back the layers a little bit. Decedent Rush was the co-founder and acting CEO of defendant OceanGate Inc. until his death on or about June 18th, 2023. OceanGate was formed by Rush for the purpose of designing, constructing, and operating manned deep-sea submersibles, including Titan, primarily for the purpose of diving to and exploring the wreckage of the Titanic. Rush actively cultivated an image as a maverick genius of the deep sea diving world. On several occasions, Rush described himself as an industry disruptor and compared himself to Steve Jobs or Elon Musk. Rush seemed to proudly flaunt convention and the rules of the industry, which unfortunately are on lots and lots of interviews. It's all recorded in lots and lots of interviews where he talks repeatedly about rules and safety be damned. We're doing it my way, which does not help the defendant's case at all. Rush seems to proudly flaunt convention and the rules of the industry, claiming that many industry rules regarding submersible design didn't make engineering sense to him. Indeed, in an interview prior to Titan's implosion, Rush even went so far as to say to journalist David Pogue that at some point, safety just is pure waste. As I was saying, things like that are not very helpful to your future defense. You might not be around to deal with it, but your family is. And to Rush, the more stuff you've broken, the more innovative you've been. Yeah, Heather Sparrow, a tube with a game controller sounds like a safe ride. Yerp. Well, Rush's devil-may-care approach to safety and obsessive quest for innovation above all else appears to have permeated the design process behind Titan. Well, now let's dip our toes into the world of this innovative but dangerous design. So this is some of the stuff that I wasn't aware of. And although some of it logically made sense, I hadn't really thought about it. But before we get there, Matt Reviews dropping the hot 5 Aussie bucks. Do you think the families would be able to get a refund for the ticket cost after this incident?
We want our money back.
It should. I'm pretty sure that would the $50 million would more than cover their ticket refund purchases. But yeah, they were promised a voyage. I don't think they were ever like the terms and conditions of the ticket promised a return from the voyage. I don't know. Interesting question. Titan's carbon fiber hull. Other than Titan, no commercial manned submersible has ever suffered an implosion. Only early military submarines have done so. No, we didn't. We didn't cover the one yet on Maritime Monday. Other than Titan, modern commercial manned submersibles for deep sea exploration are generally made from titanium for a good reason, which is that titanium is an exceptionally strong metal that strengthens under repeated exposure to high stress. Yeah, the more pressure it's under, the more dense it becomes, and the safer it becomes, honestly. Titanium is exceptionally strong. That is, with each dive, a titanium submersible can actually increase in hull strength. Matt Review says waivers don't mean shit. Oh, my friend, yes, they do. They most certainly do. Don't let anybody tell you that waivers don't mean shit. They do. Now there's adhesion contracts, which is sort of like the things that are on the back when you go into a parking garage. The stuff on the back says we're not responsible for anything that happens. Those kind of waivers are kind of semi-useless, but informed consent waivers, those can very, very, very much mean things, which is the problem that we're going to have here in just a few pages. If there's separate waivers, that's otherwise, I mean, there would be nobody would be doing, things like skydiving, parasailing. Nobody would be running businesses like those. But anyway, we'll talk about that when we come to it. Titan's carbon fiber hull. Other than Titan, we already read those. Okay. Rush believed that titanium was unnecessarily heavy. Titan's hull at Rush's direction was made from carbon fiber, which Rush called a great material and better than titanium. Well, apparently it wasn't. Just saying. In contrast to titanium, carbon fiber breaks down over time under pressure. Rush acknowledged the possibility for catastrophic failure where you have imperfections in the carbon fiber structure. Noting that carbon fiber makes a crackling noise under excessive stress, Rush proposed, now this is interesting. Rush proposed and installed on Titan an acoustic safety system to detect such crackling. Look, okay, we'll talk about it in a minute. In fact, Rush portrayed this safety system, which does need to be in quotation marks. Rush portrayed this safety system, which is nothing more than the detection of a possibly imminent failure of the carbon fiber hull in a manner in which carbon fiber is known to fail under pressure, as an advanced feature unique to the Titan in OceanGate promotional materials. Yeah, when you are that far down in the ocean and if you start hearing any of that crackling, it's too effing late. Which I think maybe leads to a little bit of the speculative nature of what's coming up later in the document here. But yeah, it's like, oh, you hear that? The hull's crackling. We're gonna squish. Yeah, mm-hmm. Titan was and remains the only submersible ever produced with a carbon fiber hull, and wouldn't be too particularly surprised if it was the only one that ever is. In addition to being constructed of carbon fiber, Titan's hull was cylindrical with hemispherical ends. This also differed from traditional submersible designs and construction. Deep-sea submersibles prior to Titan had been spherical in shape, as spheres are known to be capable of withstanding the extreme pressure of deep-sea environments. Yeah, the shape of it was a problem. CRC Duster with the song lyrics, under pressure, pressing down on me. All right. Thank you very much for the the Queen and David Bowie collab lyrics. Well, the Titan's electronic systems. Yes, we've got not only problems with the design, we've got problems with the electronic system. But before we get there, let's see. I think we have, nope, we're all caught up on the things to read. And we are now, looks like we're 75 away from Doggo-Can. Titan's electronic system. Titan was piloted using a mass-produced Logitech video game controller, normally used with a PlayStation or Xbox, rather than a controller custom-made for Titan's design and operation. People, a year out from this accident happening, a year out from this, that sentence is still one of the weirdest things I have read. The Titan was piloted using a mass-produced Logitech video game controller. It's not part of the legal argument, but at some point, don't you just get on there and you go, you're controlling this with a what? F that, I'm off. I mean, or do you go, hey, cool, I got one of those at home too. At what point do you look at a Logitech video game controller and go, oh, this is a really good idea? Well, Titan was piloted using this rather than a custom-made controller. Moreover, the controller was Bluetooth rather than hardwired, because we never have problems with Bluetooth, do we? Our Bluetooth products never randomly disconnect, do they? They never try to connect with other things, and other things never try to connect to our Bluetooth, do they? So not only do you have a video game controller, you have a Bluetooth video game controller. Look, I'm just Joe Schmo, maritime law talking guy. My PlayStation is hardwired. It has a hardwired. People think I'm living in the dinosaur ages because I have a wire attached between my PlayStation and my controller. Why? Because I don't want to be in the middle of an Elden Ring boss fight and have my batteries die. I don't want to be being chased by a gang of thieves on Red Dead Redemption and have my controller disconnect. So I sure as hell don't want to be going down to the Titanic in this death tube and just suddenly not have the controller work anymore. So yeah, disturbing one, Logitech video game controller. Really concerning the thing number two, a Bluetooth linked Logitech video game controller. Titan also had only one button for power within its main chamber. Just like, rather than hardware, okay, the remainder of its controls for lights, ballast, and so on, and gauges for depth, oxygen levels, and so forth were touchscreen. Oh yeah, because what happens if the power goes out? Well, shit. Rush stated that Titan was to other submersibles what the iPhone was to the BlackBerry. No. As with an iPhone, however, none of the controller controls or gauges would work without a constant source of power and a wireless signal. Man, Titan's hip. I think we need to continue. Like Titan's hip. That's not where that clause ends. Titan's hip contemporary wireless electronic system, which differed entirely from any previously designed submersible, were conceived and constructed by an electrical engineering team at OceanGate, composed largely of either current students or recent graduates of nearby Wazoo, Washington State University. These were engineers with virtually no real-world experience and no prior exposure to the deep-sea diving industry. You would be astounded at the level of training and competency that engineers who design the ships that float on top of the ocean need to have. The ones that go really, really, really deep down, you could say they need much, much more experience and expertise. Defendant Tony Nissen, OceanGate's director of engineering, offered to hire at least several of these engineers as interns while they were still students, when the students offered potential solutions to challenges faced by OceanGate and described by Nissen during a tour of OceanGate's facilities. The first such student hired had by 2023 become the lead electrical engineer at OceanGate at the time of the Titan's implosion, despite only being a 2017 graduate and having 6 or fewer years of relevant work experience. Plexiglass viewport. Yes, this also might pose a problem. Part of Titan's design, like the other submersibles, included a viewport through which the underwater environment could be viewed directly by occupants. It's dark out there. Once you get down surprisingly not very far, all you get to see is just sheer and utter blackness. I'm a little bit confused by the need for a viewport. Because viewports must be constructed from a different and transparent material, they present design and engineering challenges that differ from a vessel's hull. And it also weakens the hull when you put different things inside of it. The Titanic rests on the floor at a depth of approximately 3,800 meters. The atmospheric pressure at that depth is an immense 6,000 pounds per square inch. That's a lot. Every single aspect of Titan's exterior had to be engineered and built to withstand at least that amount of constant pressure while diving. The exact specifications of Titan's portholes as of June 18, 2023 are not presently known to plaintiff. However, based on documents from 2018, the plexiglass viewport on Titan at the time was rated for only approximately 1,300 meters, 1/3 of the depth at which the Titanic lay. I know the vast majority of you watching this right now are not lawyers, but do you see any problems with having a plexiglass viewport that's only rated for 1/3 of the depth that you're going down to. The same documents indicated that OceanGate was willing to spend the money required to design and construct a plexiglass viewport, which would be sufficient based on accepted standards to withstand the amount of pressure at the depths of the Titanic. So yeah, they said they could have, but they didn't want to. They're unwilling to spend the money required to design this. We know it's there's some document out there that says something to the effect of the Titanic is 3,800 meters down, but we're not willing to spend money to build a plexiglass viewport that's rated anywhere more than 1,300 meters. Now, this next section is the one that kind of caught me off guard a little bit, that I knew it, but I hadn't thought about. But first, Cherry Reed. Cherry Reed gets the foghorn. Where's the foghorn for Cherry Reed? Cherry Reed has gifted 10 Legal Vices memberships. Thank you so much, Cherry Reed. And if you are one of those 10 people that got a Legal Vices membership from Cherry Reed, make sure you give Cherry Reed a super special thanks. And that would be Bridget, Heather Sparrow, Luke C., Daily Quick Bites, Aaron, Avalak, Matt Reviews, Lynn Brittain, Erikias, and Siobhan, and Unburdened by What Has Been. Those are the lucky peeps that got the gifted memberships. Little Miss says, does Jeff see the Cash App notes on stream? Oh my gosh, I just checked that my battery is dead on my phone. So I can't, so if someone sent Cash App, I will not be able to see that right now. So the answer to that, unfortunately, is no. Oh my God, I hope nobody ever uses that. So I just noticed the battery was dead on my phone right before we started. So Little Miss. I will. Little Miss, tell me what you did. Tell me what you did here, and I'll make sure it gets a shout out. Just throw it here in chat. Well, yes, Uncivil. I've thought about plugging it in now. Well, I thought about plugging it in just as I was going on the air, but that's in the other room. Well, Kestrel, that's what you're here for. We're good. So yeah, Little Miss, just throw up how much you sent and what your note was here, and I will definitely read it here. I deeply apologize, and I will see to it that it gets charged tonight. Aha! I sent you money to upgrade your acoustic security system to full electric. Well, thank you very much. I apparently also needed to upgrade my battery charging capabilities for my phone. But how much did you send? How much did you send, Little Miss? It's important because we are now like $30 away from emotional support pig dog cam. So let me know how much you send, and we'll add that to the total. And then the $2. All right, we are now 28 away. And I got to keep track of that. All right. All right, here we go. This is the use. Thank you so much, Little Miss. You rock. That's totally awesome. This is one thing that I had thought about, but I didn't really think deeply about it. But reading through this, I went, oh, I can see how that would be a problem. Titan had a carbon fiber hull, but also employed titanium parts connected to that hull. Its viewport, as alleged above, also connected to its hull and was made from plexiglass. These different materials at various points on the Titan were necessarily joined together and sealed. Those seals were critical to Titan's integrity and safety. Above all else, it was necessary for Titan to remain pressurized, airtight, and watertight. However, at least one expert has pointed out that these three materials are very dissimilar and have different coefficients of expansion and compression. See, that's the one thing. That's one thing that I had noticed, but I hadn't thought about. Like, yeah, I know there's titanium. I know there's the carbon fiber, and I know there's the plexiglass, but all of those have different, coefficients and capabilities as far as expansion and compression goes. And if you have one thing that's expanding or compressing at a different rate than someone else or something else, that can really, really screw you up in a bad way. Because if this part is contracting differently than this part, that's going to break that seal, and that's going to cause some problems. I had just never really processed that. When joined or sealed together, the material's different coefficients of expansion and compression can lead to loosening or separation when subjected to numerous repeated cycles in depth, as would have been the case after Titan's previous dives over its lifetime. Yowzers. It was sealed with Loctite. They just bondoed it together. Russian OceanGate ignored the safety concerns of employers and others. This is kind of important here too. Nicola. In 2015, David Lockridge was hired by OceanGate. This is a lawsuit that I'm really, really tempted to look at. Legal Vices, they might be barking up the wrong tree with the viewport. Deep submersible viewports are conical in a conical frame, so the pressure makes it seal tighter so long as it doesn't break. This wasn't conical. This was convex. I believe it was convex. But anyway, they're just saying this is one of the things. The titanium parts and the carbon fiber parts, they don't sit well together, et cetera, et cetera. They're just sort of giving the overview here. But this David Lockridge lawsuit is something that I might want to look at. It's kind of interesting. In 2015, David Lockridge was hired by OceanGate as its head of marine operations and chief submersible pilot. In this position, people are asking for a picture of Titan. Quick, let's see. Titan. It's on the thumbnail. Titan submersible images. God, I hate Bing search. Bing search sucks. It sucks. All right, this is just a real quick view of the Titan submersible here. These are various pictures. So you can't really see the port there, whether it's flush or whether it's convex, but I think it's convex. I could be completely wrong, but anywho, that's what it looks like. And let's bring back up our lawsuit. Boom, there we go. And then shut the extraneous windows. There we go. So Lockridge, he was the chief submersible pilot and the head of marine operations. In this position, Lockridge was ultimately responsible for ensuring the safety of all crew and clients. Excuse me. No uncivil law. I cannot do that. In 2017, as Titan was in development and being prepared for testing, Lockridge voiced concerns about Titan's design. His concerns were dismissed, including by Rush and Nissen, allegedly because Lockridge was not an engineer. In early 2018, following an inspection of Titan prior to trials in the Bahamas, Lockridge wrote a detailed report containing his observations and safety concerns, including concerns that the integrity of Titan's carbon fiber hull, for which he had requested a complete scan. Infuriated at Lockridge's report, Rush refused to perform a scan of the hull and insisted that his acoustic safety system, much like the one that Little Miss is throwing money at me to purchase, was sufficient to detect a lack of structural integrity in the hull. At the conclusion of a 2-hour meeting addressing Lockridge's safety report, Rush terminated Lockridge. Oh, wait. You're telling us that you have questions about our safety? You're fired. That's what happened. Rush terminated Lockridge. the OceanGate employee ultimately responsible for the safety of anyone sailing on Titan. If this goes to trial, guess who's going to be one of the star witnesses for the plaintiffs? Shortly after his termination from OceanGate, Lockridge told Rob McCallum, another deep-sea explorer, as well as a close friend and longtime colleague of decedent Nargeolet, that there was no way on earth you could have paid me to dive that thing, i.e. Titan. Lockridge stated that he was worried Rush kills himself and others in the quest to boost his ego. Foreshadowing. Lockridge stated he was worried and concluded to McCallum that Titan was a lemon, that is, unsalvageable in its design as a deep sea craft. McCallum, like Lockridge, also tried to warn Rush about Titan's safety issues and seaworthiness at depth. McCallum reportedly told Rush, "You can't cut corners in the deep," and that the issues with Titan's experimental design were not about being a disruptor. It's about the laws of physics. That makes sense, doesn't it? Yeah, there's only so much innovation you can do. You still have these pesky laws of physics to deal with. McCallum had also seen the Cyclops 1, Titan's predecessor, at OceanGate Workshop. Cyclops 1 also had been controlled with a video game controller and had utilized wireless communication technology. McCallum had observed and noted that the systems were subject to multiple points of failure, and that every sub in the world has hardwired controls for a reason, namely that a loss of signal would not imperil the vessel. These observations were disregarded by OceanGate as Titan employed nearly identical systems to Cyclops 1. McCallum appeared to understand what Rush refused to believe, that based on the unavoidable laws of physics, the materials and design of Titan could not hold up over time to the challenges of deep-sea expeditions. Moreover, McCallum's warnings reflected a respect of time-tested knowledge within the deep-sea diving community that Rush and OceanGate appeared too easily to dismiss. A catastrophic disaster might not occur on Titan's first, second, or even fifth dive, but a disaster would occur. It was a matter of when, not if. Lockridge and McCallum were far from alone in voicing warnings to Rush and OceanGate over the course of Titan's development. In 2018, for instance, the Marine Technology Society sent a letter to OceanGate stating that the current experimental approach adopted by OceanGate could result in negative outcomes. Yeah, I would say that a catastrophic implosion would be a negative outcome. Could result in negative outcomes from minor to catastrophic. The BBC has notes that numerous experts had raised many serious questions about the safety of the Titan submersible prior to the Titan's fateful final dive. None of the warnings were heeded. None of the warnings were heeded. JKD Buck 76 says, I bet they heard a ping about 1,000th of a second later. They were dead. Such a waste. What a dumbass. We're going to be talking about that in just a few pages. But right now, before we move on to this next section, this would be a good time for the midstream grift here to take a look at what's going on so far. We are just about, like $28 away from unleashing the emotional support potato pig dog cam. And we have our like and subscribe poll. We've currently got 500 people watching this, 500 people watching us reading the lawsuit in the $50 million civil lawsuit filed by the administrator of the Nargeolet estate against OceanGate. And we have 366 likes. We need 130 more of you to get down there and hit that like button. And if you have not subscribed, this is what every Monday we do Maritime Monday here. So if this is something you're interested in, we're going to be continuing to follow this. We look at shipping accidents. We look at shipping problems. We look at historical things. We look at whales and cannibals and all the other cool stuff. Ghost ships. We're coming up on Halloween. So the ghost ship streams are going to start happening here in the next few weeks. Ooh, spooky. So please, if you haven't subscribed, do me the favor of subscribing. Would deeply, deeply appreciate that. And you would be awesome, wonderful people. And if you are already subscribed, just double check to make sure you still are, because YouTube is asshole and likes to unsubscribe people for no reason. And then take our like and subscribe poll. We have 125 more like and subscribe poll votes than we have likes. Shame on all of you cheaters. All right, our silly poll of the day. What is wrong with the OceanGate case? What is wrong with the OceanGate case? 15% of you said it was a titanic waste of life. 29% of you say lies and bad construction. 31% of you say it was a crushing failure. And 26% of you say no cannibalism. That's the problem. So, all right, that's the silliness that we look at. And then the like and subscribe poll, please. Again, I would be honored if you would subscribe to the channel and give me a chance, not only covering maritime stuff, but also ordinary. We got a Sarah Boone. We're going to be doing the Sarah Boone case tomorrow, the suitcase murderer. We've got something on Wednesday. I'm not sure what yet. We have an old trial from 2020 on Thursday we're going to cover. And then Friday is an unexplained stream with Flux and possibly Danny, if you can work out some schedule stuff, and a guest that is a Bigfoot hunter, ghost hunter, and possible medium. We do it all here. You'll want to be a part of this because the Vice Squad chat is the greatest chat on the entire universe, in the entire universe, on the entire YouTube platform. All right, let's get back to this, everybody. Thank you very much for the support that's coming in thus far. We've got Luke Smith with the $2, 26 away now, with a super sticker that says cool. Thank you very, very much for that. Muchly appreciated. Russia and OceanGate declined to have Titan certified. Problems. Deep sea submersibles may be and often are classified and certified by marine classification DNV. All right, now when they say classed, there's a few classification societies are called around the world. DNV is Dead Norsk Veritas. They're one of the world's leading ship classification societies. Germanischer Lloyd was another one, like German Lloyds. And gosh, I guess it was probably 7-8 years ago, DNV and Germanischer Lloyd, they merged and became DNVGL. But there's a few other, there's a Korean classification society. But what they do is they quite literally pore over every inch of a ship, and they inspect everything for safety and make sure you're meeting all of the legal requirements, all of the the treaty requirements and things like that. They're the ones that say you have a seaworthy ship. Your ship is safe. And for example, if two ships collide with each other, if two ships like just smash into each other, one of the very first things that happen is the classification society for each of the ships crawls all over their respective ship and notes all of the damage and says, you're not going to sail unless this, and this are fixed. And every year, every 5 years, they have a mandatory dry dock where they just pull the ship up out of the water and they go all over the whole thing. During your next dry docking, this has to be repaired. It's just like a repair checklist that you would get from an auto mechanic, but it's much more detailed. So yeah, these classification societies, they are the experts. They are the ones that tell you if you have a seaworthy vessel, if you meet the required standards, and if you are allowed to sail. All it takes is for your classification society to say, nope, you can't sail until this is fixed. You're done. I mean, that ship will not leave port until that is fixed. The classification societies are incredible experts, and what they say essentially is law. But as we see here, they didn't want to have it certified. Jill M says, Legal Vices, what got you into Maritime Monday? An accident. An accident got us into this. It was a day. It was a day that I was sitting here and I didn't have anything to talk about. And that's my area of expertise. That's what I do. About 70% of what I do is maritime law. maritime, admiralty and maritime related stuff. And the other 30% is general corporate law stuff. And there's a lot of overlap. So that's what I do: ship collisions, cargo damage, crew injuries, crew claims, wage claims, insurance, ship financing, vessel sales and purchase contracts. That's the majority of what I do. And I had nothing to talk about one day, and I was like, what do I do? So I went into YouTube, and I thought, I know, let's just pull up some videos of ships bumping into each other or ships hitting things. And at least I can talk about that. And I thought it would just be a disaster of a show. But everybody that watched it really, really liked it. And they're like, oh, let's do this again. So I thought, what the heck? And so Maritime Monday was born. We have a great Maritime Monday playlist. So you can go back through our history of Maritime Mondays and read all about lots of things. That's how it started. Jill M's. Nicola Maxwell with the £2. C, man, thank you. Thank you, Nicola. And Adriana got a Legal Vices membership from Duncan, Idaho. What's up? Thank you so much. Duncan, Idaho gifted the one Legal Vices membership, and apparently it went to Adriana. So that's darn cool. And wait, what? Huh? Wait. Now I'm confused. What have I done here? We have to scroll up and find out who it was. No? Alita Lee got it. Was gifted a membership by Duncan, Idaho. So, Adriana, what are you talking about? You did Duncan, Idaho. Thanks. You were just thanking him generally for the Legal Vices membership. All right. Alita Lee, thank you for helping a Utah resident. Hugs from Utah. Hey, how you doing, Alita? Good to see you here. Yeah, I know that now. It was Alita Lee. We like Alita Lee. Crazy by Proxy member for 13 months. It's wild how this lawsuit had YouTube recommended. It's wild how this lawsuit had YouTube recommended what happened after the attack at Pearl Harbor. International stuff. Thank you very much, Crazy by Proxy, for being a member for 13 months. I get some weirdly juxtaposed membership recommendations as well. There's some weird things happen. All right, let's jump back into this, shall we? Yes, it was a general thank you. Swamp Bear X says, so if the Nostromo was a ship on the ocean, would Wayland Yutani owe a ton of money to the families of the crew based on current maritime law? Well, no, because they scuttled it. They were actually, no lie. If you go back through the Maritime Monday playlist, it was last, not this April, but it was last April. It was part of our April Fool's Monday, Maritime Monday in 2023. We did a study of the Nostromo, the scuttling of the Nostromo. So yeah, go back into the that's the ship from Alien. For those of you that don't know, I actually did with Maritime Horrors. we from the channel Maritime Horrors. We had him on here, and we went through the Nostromo. So all right, thank you very, very much for all that support. Let's jump back into this. We got some ground to cover. Let's talk about them declining to be classified by world-renowned top of the heap DNV. Classification and certification involve the use of a DNV engineer at every stage of the submersible's creation. And literally, when you're building a ship, when you're building one of these massive, gigantic container ships or cargo tankers, it was quite. They literally, the DNV representative will have an office right there on the construction site where they literally sit and watch the ship being built. Alita says, thank you, Legal Vices. Jeff, I met Danny on direct last Thursday in person at Corey Richardson's. Got a gift sticker just like you with a sticker. Aw. Yeah, I'm glad you got to meet Danny. Danny's good people. She couldn't come out to hang out with peeps when I was there in May and June because she was over here in Korea still. But glad you got to meet her. And Heather Sparrow with the $5. Maritime Monday and Retro Thursday are my favorites. Love the chat and loyal crew. Plenty of semen. Thank you very much, Heather Sparrow. Let's moving right along. We're closing the gap here. Stuff looks like we're about 15 away. Deep sea submersibles are classification and certification involve the use of a DNV engineered every stage of the submersible's creation, from design to sea trials to diving. DNV certification is rigorous and reflects a submersible's compliance with the most current and accepted standards of deep sea diving practice and technology. For instance, the limiting factor is a submersible designed and built by Triton submarines, which had in the years prior to the Titan's final voyage dived to the deepest points in each of the world's oceans. I believe is that James Cameron's vehicle? I think that might be James Cameron's. Dived into the deepest points in each of the world's oceans, including the immensely deep Mariana Trench. Decedent Nargeolet had, with his friend Robert McCallum, participated in the Limiting Factor's voyages. The Limiting Factor had been designed in collaboration with DMV. Not the DMV. That was the last people you want to have designing your ship or in checking it is the DMV. Good grief. DNV had been designed in collaboration with the DNV and had been certified and granted a depth rating of unlimited. Rush and OceanGate, by contrast, declined to seek DNV certification for Titan. Rush believed it would be too difficult to educate DNV personnel, who are by any measure world-class experts on the requirements and dangers of deep-sea diving, on the purported advantage of Titan's innovative design. Yeah, he's saying, oh, it would take too much effort. It would be too difficult to explain to them why I know more than them. Yeah, sorry. I would trust my life to a DNV person. And, geez. This is terrible. Rush appears to have believed that DNV, like nearly everyone else in the industry except for himself, were stuck in and held captive to the past. As a result of Rush's OceanGate failure to seek classification and certification for Titan, there were no independent or third-party sources for information or assurances regarding Titan's safety and seaworthiness. Only Rush and the other OceanGate personnel themselves. So only OceanGate and Rush, they were the only ones that were really, really qualified enough to understand how the submersible operates and why it's okay to do it the way they wanted to do it. Now, all right, we've got to take this very, very quick break here because all sorts of things have been happening while I read that little section. Jill M's, release the hounds by your command. Duncan, Idaho, gifted one Legal Vices membership. Duncan, Idaho, who got that one Legal Vices membership? It went to Ginger with a Soul. Ginger with a Solo got the Duncan, Idaho gifted membership. So we have unlocked the first achievement of the day. And for that, I have to turn the veranda light on. So give me just one quick second while I wheel across the room. Turn the light on. Wheel back across the room. Wheel back across the room. Turn the camera. And there we go. Yoda is out in the hallway, but we have reached that time of the show, that first unlocking of the achievement, which we like to call Release the Hounds. And here is Strawberry. We'll zoom in on Strawberry and then very quickly resume what we're doing. Let's do a little Strawberry zoom. And of course, as soon as she's been sitting there for 25 minutes now. As soon as I do that, she's going to get up and move because that's just what she does. All right. And just a quick glance. That's Strawberry, the one of my two English bulldogs. If this is your first time seeing the emotional support potato pig dog cam, that's Strawberry. All right. Strawberry and I will now move forward. Thank you so much, everybody, for unlocking the first of our achievements. If for some reason the second achievement is unlocked, we'll deal with it at that point. Right. So this is where another part of this is interesting. Russian OceanGate hired Nargeolet but failed to disclose material information. This is where we talk a little bit about the waiver that was signed. As alleged above, decedent Nargeolet was a legend within the deep sea diving community, known as Mr. Titanic. Sorry, no Shaggy. By almost all accounts, Nargeolet was obsessed with the Titanic, taking advantage of every opportunity presented to him to visit it. Altogether, Nargeolet dove to the Titanic 37 times over his lifetime. That's a lot. Decedent Nargeolet's deep knowledge and prior experience at the Titanic shipwreck site meant that he, perhaps more than any other human being, best knew the position and layout of the Titanic on the ocean floor. Nargeolet was uniquely qualified to guide a submersible and its pilot around the many potential dangers presented by the shipwreck, and to explain to persons on the submersible what any viewable portions of the Titanic wreckage were. The reasons are precisely why OceanGate hired Nargeolet as a crew member aboard Titan. Nargeolet's role was to act as a navigator near the Titanic based on his detailed knowledge of the site, to act as a guide explaining to other crew members what they were seeing, and to collect scientific data, identify degradation and wreckage changes, and similar tasks. Nargeolet was also well qualified to act in almost any other capacity required on a submersible voyage. As a lifelong diver obsessed with the Titanic, it was easy to see why Nargeolet would want to take the job. And he also paid $250,000. Decedent Nargeolet knew that the Titan was different from other submersibles in that it was constructed from carbon fiber and used other unusual materials and components. However, Nargeolet was not an engineer, a submersible designer, or a physicist. Nargeolet appears to have been persuaded that Titan's carbon fiber hull construction was safe by implication. Nargeolet had been told by Rush that he was, quote, working with Boeing, with a big company. And when you see the way they were doing the cylinder, it's not in a garage, you know, with glue and stuff like that. Kind of seems like it might have been, actually, like glue and that sort of stuff. Ugh. The imprimatur of Boeing as a co-developer and or co-manufacturer alongside OceanGate, along with Russia's related insinuations that the University of Washington was also involved with the company's submersible design and construction, gave Nargeolet the apparent assurance that serious minds and deep pockets were participating alongside Rush and his team. The problem is that the assertions by Rush were simply not true. Both Boeing and the University of Washington, while being forced to acknowledge some degree of limited participation or consulting with OceanGate and Rush on Cyclops 1, now deny that they were involved in the development of Titan. So in other words, he lied. Furthermore, for all of Rush's projected confidence in carbon fiber as an appropriate and superior material for submersible construction, Rush confessed to a mission specialist on one Titanic voyage that he had gotten the carbon fiber used to make the Titan at a big discount from Boeing because it was past its shelf life for use in airplanes. Yeah, that does not help the defense's case at all. The respondent here in this lawsuit is not in a good way with things like this. He got the carbon fiber used to make the Titan at a big discount from Boeing because it was past its shelf life for use on airplanes. Yeah. Oh, expired. Great. Yeah, it was past its shelf life, and that didn't raise any flags. The mind boggles. Well, it can't handle the air real good. I'm sure it'll handle the bottom of the ocean. there you go. There's some problems. Nargeolet took Russia's assurance that Titan's seaworthiness and construction at face value, believing that other reputable and trustworthy companies or institutions had given Titan their stamps of approval. Rush knowingly had implied that Boeing and the University of Washington were involved with the project in order to preempt or assuage any concerns Nargeolet may have had about Titan's experimental construction. Rush furthermore made additional assurances to Nargeolet about the capabilities and safety features of Titan and its construction materials that Rush knew or should have known were not true and or were not supported by the level of scientific evidence he claimed. In short, neither Rush nor OceanGate had ever fully or accurately disclosed all of the material facts that Titan's design and construction facts regarding Titan's design and construction to deceive Nargeolet. On the contrary, Rush and OceanGate actively fostered Nargeolet's and others' false impressions about the safety and seaworthiness of the vessel. All of this is going to come together here in a little bit. But now we're going to be talking about the implosion itself. This is where we get into what I think is a little bit of wishful thinking, a little bit of speculation. But let's take it one section at a time, shall we? The unclassified and experimental Titan dove to the depth of the Titanic only a limited number of times prior to June 18th, 2023. As explained above, each of those prior dives could have or would have weakened Titan's carbon fiber hull and or construction and or connections and seals between disparate types of material. On June 18th, 2023, decedent Nargeolet and Rush joined Pakistani businessman Shahzada Dawood. Okay, that's the guy. It wasn't Rush's son. It was the Pakistani businessman Dawood and Dawood's son Suleiman and British billionaire Hamish Harding aboard the Titan to descend to the Titanic. That's right. It was Dawood and Dawood's son. It's all coming back to me now. To secure their places aboard the Titan, the Dawoods and Harding presumably would have donated $250,000 each to OceanGate exploration efforts and been trained in the vessel's operations on additional crew members prior to the voyage. So does this mean that Nargeolet didn't have to pay the $250,000? That's interesting. I thought they all did, but anyway, that's beside the point. OceanGate required all crew members, or mission specialists as he called them, to sign a waiver and release prior to any dive. All right, here's the waiver we've been talking about. And it's acknowledged by the claimants that Nargeolet did in fact sign this waiver. Before we get into that, Bad Weather Biker, how you doing, brother? Good to see you here. At this point, the very name Boeing is past its shelf life for use on aircraft, spacecraft, and apparently watercraft. Unfortunately, there's a great many of all of those still out there, and we use them each and every day. Good luck, peeps. Here is this infamous waiver that was signed. This operation will be conducted inside an experimental submersible vessel that has not been approved or certified by any regulatory body and may be constructed of materials that have not been widely used in human-occupied submersibles. Travel in and around the vessel could result in injury, physical injury, disability, emotional trauma, or death. The support vessel could expose me to property damage, injury, disability, or death. Assisting in the operation of the sub could lead to property injury, disability, or death. Out of 4 paragraphs, well, essentially 4 sentences, out of 4 sentences in the waiver, 3 of them do in fact mention that you could die. This waiver is actually a big problem for the claimants, because this is a pretty specific waiver. Like I said, this isn't one of these things that like when you give your clothes to the laundromat and they say we're not responsible. They give you your ticket, and on the back of the ticket it says we're not responsible for any loss of clothing or something stupid like that. Or if the back of your parking ticket, when you enter the parking garage, it says we're not responsible for any damage to your vehicle or losses to any. Or your hotel, when the hotel says they're not liable for anything. Those are adhesion contracts. Those are generally very problematic for the people that try to rely on them. But this is a specific separate waiver. A specific separate waiver that they're given time to consider, and they can go, F this, I'm out. This is a pretty specific waiver. I think it's quite problematic, and they essentially admit it's problematic in here. But if you just look at the first, you are going to be inside an experimental craft that nobody has certified or approved, and the stuff we made it out of, not many humans have ever gone down in the ocean in it. So we're using shit that people don't normally use to go down in the ocean, and nobody has approved or certified this. And then traveling in it can kill you, the support vessel can kill you, and working on it can kill you. Very, very specific waivers that they signed. Problematic. So how do they deal with this? This is a basic, but actually I think it's a pretty good waiver. Well, this is how they deal with it. The waiver and release failed to disclose many key relevant risk factors detailed above regarding the design and operation of Titan or other materials used in its construction. Further, OceanGate's waiver is insufficient and ineffective to relieve OceanGate of liability for its own gross negligence and or misrepresentations to Nargeolet. So this is how they deal with it. They say, yes, we realize that the deceased client signed this waiver. We understand that, but they disclosed some of the risks, but they didn't disclose really other really important risks. They didn't disclose other serious risks. So had they disclosed these other risks, our guy probably wouldn't have gone. So they're saying that, yes, they did disclose some risks, but not really. They failed to disclose some really, really important risk factors. And you can't waive in your intentional act or gross negligence. You can't just say, all right, they signed a waiver. We can kill everybody on board and not have to face any consequences. If the waiver might cover general negligence, but they're saying if it's an intentional act of lying about how safe it is, lying about the risks, and gross negligence. If it's gross negligence is almost the level of an intentional act. It's like you give so few F's about whatever it is you're doing that it almost rises to the level of an intentional act. So they're saying if it's grossly negligent for him to operate this submersible and he lied about it, this waiver should not be effective. It should be ineffective. So this is very interesting. They're not saying, oh, the waiver itself is useless. They're saying, okay, it is a real waiver and it was signed by our guy, but it was flawed for these reasons. You can't waive your liability for gross negligence. And I mean, you can't avoid liability for your gross negligence. And you lied and you failed to disclose some very important risks. I think he's got an argument. So this is going to be an interesting part. I think these two sentences here are going to be a big part of the battle in this lawsuit. Was the waiver fatally flawed? Yeah, well, no. I mean, I know. I assume you're usually making a fatal joke, but no. I don't think it's fatally flawed from a legal perspective. Let's set aside the humor perspective for a minute. Approximately 90 minutes. Now, this is where we start to get into the speculative part, where I think maybe this is a weak part of the case, but they have to argue it. Approximately 90 minutes into the Titan's dive on June 18th, 2023, it became clear that something was wrong. At a depth of approximately 3,500 meters just above the Titanic, the Titan dropped weights, indicating that the team had aborted or attempted to abort the dive. Shortly thereafter, the Titan lost communications with a surface support ship. After that, the Titan's tracking system also failed. The Titan and its crew were gone. The United States Navy later confirmed what had been widely suspected. Approximately 90 minutes into the Titan's dive, the naval acoustic devices observed an acoustic signal consistent with a catastrophic implosion in the vicinity of the Titan. The United States Coast Guard is pursuing an ongoing investigation into the Titan explosion. Now, here's where we need to pause and mention something important. The Coast Guard will be holding a week-long session of hearings. They're going to be holding a week-long hearing on the Titan implosion beginning on Monday, September 16th. And it'll go as long as necessary up to and including that Friday. It will be streamed live. So I will be covering the Coast Guard hearings on the Titan submersible. So we will watch that beginning with Maritime Monday on Monday, September 16th, and we will go through it as long as it takes. So Aaron, you will be able to see that. I will cover it here on this channel. So if you want to watch the Coast Guard's Titan hearings, please mark September 16th on your calendar as the start date. They said it will go every day as long as necessary and up through the Friday if it takes that long. All right, so the Coast Guard is pursuing an ongoing investigation. Their public hearings start on the 16th of September, which I will be covering. It may be never known for certain exactly which of the multiple points of failure identified by Rob McCallum and others was responsible for the implosion, or whether the implosion resulted from a daisy chain of failures of multiple improperly designed or constructed parts or systems. Little Miss says as long as necessary, so 45 minutes. Oh, wow. The Coast Guard, they love hearings and they love writing reports. This might go the entire week. And I mean, their accident reports can be in the several hundreds or 1,000 or more pages at a time. So there's some Coast Guard's got nothing better to do but write reports. What the exact cause of failure may never be determined. Experts agree. While the exact cause of failure may never be determined, experts agree that the Titan's crew, this is the speculation part I was talking about. Experts agree that the Titan's crew would have realized exactly what was happening. Russia's vaunted acoustic safety system would have alerted the crew that the carbon fiber hull was cracking under extreme pressure, prompting the pilot to release weight and attempt to abort. Common sense dictates that the crew were well aware they were going to die before dying. That is speculation. But it has to be argued because it goes towards mental anguish and suffering of the deceased and things like that. I would agree with what JKD Buck said earlier. If they heard any of the crackling, I think, and this is just me speculating, just based on pressures at that depth and whatnot, and the way it's been described, they would go, "Oh, do you hear any crack smash?" I don't think. I mean, what? Because once, I mean, at those depths, it's 6,000 pounds per square inch. Once you hear the crackling, it's over. I would guess. I mean, I don't think there was a long time for a discussion about, gee, we're going to die. Let's write notes to our family. It would seem like it would be fairly instantaneous. And once the implosion began, it's measured in thousandths of a second. So again, that's just my thought. This seems pretty speculative, but it is obvious that Russia's safety mechanism to drop weight in response to hull crackling did not work. We don't know why they tried to drop their weight. and to stop descending. We don't know why, but assuming it was because of the hull cracking, it didn't work. The crew may well have heard the carbon fibers crackling. See, again, it's very, even they know it's speculative. May well have. They may well have heard the carbon fibers crackling noise growing more intense as the weight of the water pressed on Titan's hull. The crew lost communications and perhaps power as well. By experts' reckoning, they would have continued to descend in full knowledge of the vessel's irreversible failures, experiencing terror and mental anguish, which we can claim money for, experiencing terror and mental anguish prior to the Titan's ultimately imploding. At all relevant times, the vessel Titan was owned, operated, managed, and or controlled by one or more defendants. Now, see, I want to talk a little bit about this experiencing terror and mental anguish. You know, I don't know what the U.S. law position is on damages for pain and suffering for deceased that die instantly. But Korean law has it's a theoretical time period of pain and suffering. So, you know, if you're sitting, let's just take an example. You're sitting there minding your own business, and a bullet enters your head, and you're gone that fast. You didn't even know there was a bullet coming your way. You just get shot in the head, and you're gone. Korean law has this legal theory that at least for the instant, the micro instant between the time something happened and the time you died, there was pain and suffering. So they've created this legal fiction of you don't have to be suffering for a second or a minute or an hour or a week to get pain and suffering. It's this instantaneous pain and suffering between, even if it's a hypothetical time frame between the act that causes your death and your actual death. So that way the deceased heirs can claim pain and suffering for on behalf of their loved ones who died instantaneously. So that's a very interesting legal theory that I quite like. So anyway, at all relevant times, the vessel Titan was operating in navigable waters of the North Atlantic near the Titanic wreckage. An implosion of the Titan violently resulted in the deaths of all members on board, including decedent Nargeolet. Defendants OceanGate Inc., Tony Nissen, Electro Impact Inc., Hydrospace Group Inc., Janicki Industries Inc. participated in the design, engineering, and manufacturing of the Titan submersible vessel. Defendant Electro Impact Inc. laid the carbon fibers for the Titan's second hull, and the carbon fibers were laid out. Defendant Janicki Inc. cured the materials in its ovens. Defendant Hydrospace Group manufactured the acrylic viewport on board the Titan. Defendant OceanGate Inc. and Tony Nissen participated in or supervised the design of the Titan vessel and its predecessor, Cyclops 1. Tony Nissen was an employee of OceanGate during the development and manufacturing of Titan. His role as director of engineering at Defendant OceanGate included, but was not limited to, managing various engineering priorities and providing support and technical oversight in the implementation and operation of the submersible vessel Titan. Tony Nissen's scope of employment at Defendant OceanGate also included supporting the Titan's machinery, launch and retrieval equipment, system design, documentation, planning, troubleshooting, certification, oversight, and project management, and designing the viewport used in the final iteration Titan. Now, here's the causes of action. Here's where they're asking for the moolah. Here's their grounds for why they think they're entitled to all of this money. $50 million is what they're asking for. Plaintiff reavers and realleges each and every allegation of fact and law contained herein as if repled in their entirety. So what that means is, in this paragraph, just pretend that we repeated everything we just said in the previous 15 pages. A plaintiff brings this cause of action against defendants jointly and severally. That means any one person can be held liable for $50 million, or other people, you can break up the $50 million between the various defendants. Jointly and severally, pursuant to general admiralty law and the laws of the state of Washington, at all times pertinent herein, one or more defendants owned, operated, controlled, and or manned the Titan submersible vessel, On June 18th, 2023, the Titan imploded in navigable waters in the North Atlantic Ocean off the coast of Newfoundland, Canada, and beyond 3 nautical miles from the shore of the United States. In other words, international waters. As a result of the implosion, PH died on board the Titan. The implosion of the Titan and the resulting death of decedent Nargeolet was caused by the wrongful act or negligent or neglect of one or more of the defendants, including their respective officers, agents, or employees. I forgot to mention this. This is wrongful death. This is the action for wrongful death, negligence, and gross negligence under Admiralty law. At the time of the underlying occurrence, one or more defendants were careless, negligent, grossly negligent, and reckless in the following respects. So this is the laundry list of how they were negligent: in failing to provide a safe working environment, in failing to take reasonable precautions during the design, manufacturing, testing, and operation phases of the submersible vessel Titan, in failing to enact and enforce safe policies and procedures for the task at hand, in failing to take reasonable precautions to ensure the safety of the crew on board, in failing to properly train and supervise the crew of the vessel, in failing to provide warnings of unsafe conditions to those on board the vessel, in failing to act in a reasonable manner after design flaws and safety issues were identified and repeatedly notified to the company's governors from both within OceanGate Inc. itself and external sources, in misrepresenting the overall hazards associated with operating the submersible vessel Titan, in misrepresenting the submersible vessel Titan's operational capabilities and safeness, in misrepresenting OceanGate Inc.'s prioritization and attention to safety in both designing, manufacturing, and operating the submersible vessel Titan, in failing to address clear warnings from industry experts, engineers, consultants, component manufacturers, and test pilots who all identified the submersible vessel Titan was not capable of repeatedly diving to the depth of the Titanic, and other negligent acts or omissions as proven at the time of trial. Throat's getting dry. The death of PH caused injury and damages to the beneficiaries of PH in an amount to be proven at trial. The second cause of action for negligence and gross negligence under the Jones Act. Remember, under the Jones Act, this part of the Jones Act being sort of like the Workers' Compensation Act for crewmen, for seafarers, as we're calling them today, you need to prove negligence. Well, again, everything we said above, we said again here. This is the cause of action under the Jones Act. Again, the defendant owned, operated, and hired the crew. Nargeolet was employed by one or more of the defendants. Nargeolet contributed to and aided the submersible vessel Titan in its mission on navigable waters. Nargeolet was tasked on board the submersible vessel Titan with aiding in navigation near the Titanic wreckage, collecting scientific data, identifying degradation and wreckage changes, and identifying portions of the Titanic and other crew members. They're setting him up as a seafarer, as a crewman, so that he is able to take advantage of the higher compensation amounts under the Jones Act. Decedent Nargeolet performed his role on each mission of the Titan during his employment with OceanGate, including the voyage on June 18th, 2023. Decedent Nargeolet spent in excess of 30% of his time working on Titan or its supporting surface ship in the same fleet. Nargeolet could not perform his assigned duties without being on the Titan, and the Titan could not complete its mission without Decedent Nargeolet being on board. Will there be a trial? I mean, it will be years and years and years before there's a trial. If there's a trial, I would guess they will reach a settlement at some point. Would they televise it? Probably not. Nobody really cares about civil cases like this, and they certainly wouldn't care about it 5, 6, 10 years from now. Who do they sue if the owner is gone? That's who they're suing in this case. They're suing the estate of the owner. They're suing the company. They're suing the guy that designed it. They're suing the guys that made the porthole glass, the plexiglass. They're suing pretty much everybody that had anything to do with the design and creation of it. Where are we at here? On June 18th, 2023, while the Titan was engaged in navigation, the vessel imploded, killing Decedent Nargeolet and all others on board the vessel. The implosion of the Titan and the resulting death of decedent Nargeolet was caused by the negligence of one or more defendants, including their respective officers, agents, or employees. The death of PH caused injury and damage to the beneficiaries, to his heirs. At all relevant times, it was feasible for defendant to provide to decedent Nargeolet and said defendants owed to decedent Nargeolet duties of care. Again, this is what I said, you have a duty of care, basically not to kill them. Two, they have to have breached the duty of care, and there had to have been damage as a result of the duty of care. Those are the things you have to prove under the Jones Act. So yes, they owed a duty of care, inter alia, a safe place to work. It's if it's not specifically stated, that is an implied duty of care. You're supposed to provide your employees a place that won't kill them. Plaintiff further contends that on the occasion in question, the defendants acting through their officers, agents, servants, or employees were careless and negligent in breach of the duty. Again, you owe a duty of care, you breach the duty of care. Now they're going to tell us how they breached the duty of care and then the damages. At the time of the underlying occurrence, one or more defendants were careless, negligent, grossly negligent, and reckless in the following respects: in failing to provide a safe working environment, in failing to take reasonable precautions during the design, manufacturing, and testing, and failing to enforce safe policies and procedures for the task at hand, in failing to take reasonable precautions to ensure the safety of the crew on board, in failing to properly train and supervise the crew, in failing to provide warnings of unsafe conditions to those on board the vessel. You see, there a lot of these overlap. In failing to act in a reasonable manner after design flaws and safety issues were identified and repeatedly notified to the company's governors from both within OceanGate itself and external sources, in misrepresenting the overall hazards associated with operating the submersible vessel Titan, in misrepresenting the submersible vessel Titan's operational capabilities and safeness, in misrepresenting OceanGate Inc.'s prioritization and attention to safety in designing, manufacturing, and operating, in failing to address clear warnings and other negligent acts or omissions as proven at time of trial. Luke Smith has sent us the $5 super sticker. How's it going? It's going well, man. Just the throat's a little bit scratchy. We're talking fast and reading a lot today. Can't wait to relax tomorrow with some Sarah Boone trial hearings. All right, on or about June 18th, 2023, and as a direct and proximate result of the negligent act. So as a result of their negligence, decedent Nargeolet sustained fatal injuries. That's the damage. They owed the duty of care not to kill their employees. They breached it by having lots and lots of negligence, and that negligence killed the claimant. So that's the three things they need to prove. As a direct and proximate result of the negligent acts, decedent Nargeolet sustained fatal injuries, which resulted in injury and damages to his surviving beneficiaries. Said occurrence and injuries occurred as a result of the negligence of defendants, their agents, servants, employees, acting in the course and scope of their employment or agency. Yes, they have to be acting in the scope of their agency or the scope of their employment. Third cause of action for vessel's unseaworthiness under general maritime law. They're arguing the ship was not seaworthy and never should have gone, never should have left anywhere, never should have gone into the water, let alone under it. Everything that was said above, we're saying again, we're bringing this cause of action, vessel unseaworthiness, pursuant to the general maritime law grounds of the United States of America. Titan was owned and operated by OceanGate Inc. and one or more defendants. The death of PH was caused by defendant's breach of the absolute duty to furnish a seaworthy vessel. That's an important thing. Seaworthiness is the utmost obligation. Anyone who owns a vessel has an absolute, overriding, utmost absolute duty to provide a seaworthy vessel. If your ship is found to be not seaworthy, you are intercoursed in just about every way you can possibly imagine if there's an accident. And so there's an absolute duty to furnish a seaworthy vessel. At all times, defendant owed a duty to furnish a vessel that was seaworthy in all respects with a reasonable safe equipment and gear. On June 18th, 2023, dangerous and unseaworthy conditions existed aboard the submersible vessel Titan. As a result, decedent Nargeolet sustained catastrophic injuries and death. Defendants failed to take reasonable and necessary steps to ensure the safety of the vessel's crew. On or about June 18th, 2023, the submersible vessel Titan was unseaworthy in the following particulars. Now, here's the laundry list of the ways in which the vessel was not seaworthy. Nice sibling creature. That's funny. The vessel was functionally incapable of performing its intended use in a safe manner. That's pretty strong right out of the gate. The vessel lacked proper safety systems to protect crew members. The vessel lacked proper dive monitoring equipment on board to protect crew members. The vessel was defectively designed in a manner that was unreasonable in accordance with its intended use. The vessel was defectively manufactured in a manner that was unreasonable in accordance with its intended use. The vessel lacked proper safety equipment for conducting deep water exploration on the Titan wreckage. The vessel was outfitted with unfit components as they were incapable of withstanding operational exposures associated with the intended use of the vessel, and other unseaworthy conditions as proven at time of trial. These breaches of duty, again, you owe the duty, you breach the duty, the damage happens. As the breach of these duties proximately contributed in whole or part to cause the death of defendant Nargeolet, which resulted in injury and damages to his beneficiaries, and for which defendants are liable to the plaintiff in damages. Products liability. There's a product liability case in here somewhere. This is the fourth cause of action. I believe it's maybe there's, I can't remember if there's 4 or 5, of course, causes of action. Just on implosion's not enough. Well, it is enough, but you have to explain. You have to do lawyer stuff. You have to explain how it happened, because you have to say, okay, their negligence contributed to the implosion. And yes, you have to prove that the implosion actually did kill the person. All right, products liability claims. Plaintiff repeats everything that was said above, maintains the action jointly and severally, again, against one or everybody, under the general maritime law of the United States and or Washington Products Liability Act. To varying degrees, defendants designed, assembled, built, manufactured, distributed, and or produced the submersible vessel Titan. Defendants, as manufacturers, designers, assemblers, builders, or distributors of the submersible Titan, owed to decedent, here's the duty of care, a duty of care to supply a safe and non-defective submersible. Yes, they had a duty to supply a submersible that wouldn't implode. To all foreseeable end users, including a duty to exercise reasonable care in product manufacture. Well, they breached that duty of care in the following ways. The subject vessel was unreasonably dangerous in the following ways. In construction or composition, because the carbon fiber hull was not properly tested for integrity. In failing to heed countless warnings about flaws in the vessel's design and manufacturing process, and instead choosing to assemble and manufacture the vessel in its final iteration. In designing and implementing a hull stress acoustic monitoring system. That is so stupid. In design and implementation of the viewport, which was not rated for the intended operational depth of the vessel. That is a big, big problem. That viewport that was rated only for 1,300 meters and not 3,800 meters. That is a huge problem. That is, from a product liability standpoint, that's a big one. The failure to implement reasonable testing to components prior to assembly. The failure to provide adequate warnings of potentially dangerous characteristic created by the design and manufacturing flaws, and in other manners to be proven at the time of trial. The subject suffered from suffered from a multitude of defects in design, specifically the decision to construct the vessel's hull entirely out of carbon fiber, the design and implementation of an inadequate and ineffective hull stress monitoring system, and the design and utilization of the vessel's viewport with a depth rating less than 20% of depth required to reach the Titanic wreckage. As I said, that is a huge problem. These design defects caused the vessel's hull to fail after being exposed to the extreme pressures experienced when diving to the depths of the wreckage of the Titanic. This resulted in the vessel's implosion on June 18, 2023, which is the legal, direct, and proximate cause of the death of decedent Nargeolet. The vessel was in an unreasonably dangerous condition as a result of the carbon fiber hull acoustic monitoring system, and or the vessel's viewport when it left the control of one or more of the defendants. The subject vessel suffered from a defect in manufacturing, specifically the lamination and curing of the carbon fiber hull. This caused the hull to fail after being exposed to the extreme pressures faced by the vessel as it dove to the wreckage of the Titanic. The death of decedent Nargeolet on June 18, 2023 was without fault on his part. Now remember, I said that under the Jones Act, not only do they look at the negligence of the employer, in this case, OceanGate or the others, they also look at the person's own negligence. So if a court says, all right, the employer was 50% responsible and the claimant was 50% responsible, you only get 50% of your claimed amount. If they find out that the employer was 10% negligent and you were such a schmuck that you're responsible for 90% of your damages, the accident was 90% your fault, you only get to claim 10% of your provable damages against your boss. But then flip-flop that around. If the employer is 90% and you're 10% responsible, you get to claim 90%. So they say here that our client has 0% liability. The decedent Nargeolet had no fault. He had no contributory negligence. So they're saying he gets 100% of his provable damages. That's what they're arguing. And it'll somehow be up to the defense if they want to reduce if they're found liable, if they want to reduce any of the liability, they're somehow going to have to find a way in which Nargeolet was negligent. So the death of decedent Nargeolet on June 18, 2023 was without fault on his part and was caused by a defect in design, composition, or manufacture of the submersible vessel Titan. And these conditions existed at the time the vessel left its manufacturer's control and are resulted from a reasonably anticipated alteration or modification of the vessel. The condition of the submersible vessel Titan, i.e. the hull's carbon fiber design, hull monitoring system, viewport, and lamination and curing of the vessel's carbon fiber hull was made the vessel unreasonably dangerous to normal use. By reason of the foregoing, and as a legal result thereof, decedent Nargeolet suffered catastrophic injuries that resulted in his untimely death. These injuries and his death occurred as a result of the negligence of one or more of the defendants, their agents, servants, or employees acting in the course and scope of their employment or agency. Now, this is the last court. There are, in fact, 5 causes of action. This is just wrongful death under Washington state law. Plaintiff repeats everything that was said above. It's the claim against all the defendants under Washington law. All relevant times, the defendant owed a duty of ordinary care to not injure or kill the people that are using the submersible. As a result of the wrongful acts and negligence of one or more of the defendants, decedent Nargeolet suffered a catastrophic injury and death due to the vessel's implosion on or about June 18, 2023. The death of decedent Nargeolet caused injury and damages to his surviving beneficiaries. So these are his beneficiaries going, we had damages too. The breaches of alleged duty herein on the part of one or more of the defendants proximately contributed in whole or in part to cause the loss of life of decedent Nargeolet, for which defendants are jointly and severally liable to plaintiffs in damages. Well, some or all of the wrongful acts and negligence of said defendants are pled herein. So all the stuff we talked about, all the negligent stuff we talked about above, including the failure to take corrective action and numerous design and manufacturing flaws, were identified. The failure to protect those on board, the misrepresentation of the vessel's operational capabilities and safeness, and the lack of attention to safety in designing, manufacturing, and operating the vessel constitute gross negligence. That's more than regular negligence. It's just essentially an utter disregard for the possible outcomes. One or more of defendants were aware of the prior issues with the submersible vessel Titan before June 18, 2023. Despite prior awareness of the vessel's design and manufacturing flaws and the well-known risk of serious injury and death that can result from diving to the extreme depths needed to operate at the depth of the Titanic wreckage, defendants failed. Oh, there's six causes. I'm sorry. It's the pain and suffering one I forgot about. The extreme death needed. Okay. Defendants failed to take adequate corrective action to protect or warn others. Because the wrongful acts and negligence of defendants constitutes gross negligence, plaintiff is entitled to recover both economic and non-economic damages from said defendant under Washington Revised Code. And finally, pre-death pain and suffering and mental anguish. So this is where they're gonna rely on they heard crackling noises and they had to sit there and wait for their deaths. That's why I said it's speculative, but Korea gets around this by saying that even if their death was instantaneous, there's still a theoretical time between the moment that the bullet pierced the head and the moment of death. You know, you don't need to prove that there was this. It was just, anyway, this isn't a Korean law thing. It doesn't matter. Plaintiff reavers and realleges each and everything that was mentioned above. Plaintiff brings this survival action against the defendants for the pre-death pain and suffering of decedent Nargeolet. Prior to his violent death, PH sustained conscious pre-death pain and suffering as a result of the negligence of one or more defendants. He knew he was going to die, and that caused him pain and suffering. And the damages. Everything we said above, we're including here. The death of PH was a direct and proximate result of the occurrence alleged herein. By reason of the foregoing, plaintiff, as administrator CTA of the estate of PH, comes now and sues. Plaintiff maintains this suit for the benefit of the beneficiaries allowed to recover for the wrongful death of PH under the Jones Act, General Maritime Law, and Washington State Law. Plaintiff, as the administrator of the estate, would show that the beneficiaries of PH have suffered a loss of support, both financial and emotional. They lost their husband, they lost their dad. The beneficiaries have suffered enormous mental anguish, loss of financial support, and loss of inheritance. Plaintiff would also show that decedent's children have suffered a loss of parental consortium. They don't get to hang out with their dad anymore. Parental consortium, companionship, love, affection, and household services and in a reasonable probability will suffer a loss of parental consortium, companionship, love, affection, and household services into the future. Plaintiff would also show that decedent's widow has suffered loss of consortium, companionship, loss of consortium, like between parent and child. The loss of consortium is we don't get playtime with dad. Decedent widow suffers loss of consortium. This is literally a claim for can't have sex with him anymore. Loss of consortium is we can't do our husbandly and wifely actions together anymore. We've lost the ability to have sex with each other. The loss of consortium, companionship, love, affection, and household services in a reasonable probability will suffer loss of these into the future. Plaintiff, as an administrator of the estate, makes a claim on behalf of the proper beneficiaries for all damages available under the Jones Act, General Maritime Law, and Washington State. And all of these people here, all of the defendants, are jointly and severally liable to the plaintiff, who brings this suit for the benefit of all beneficiaries allowed for the following damages. Here's the damages they want: loss of support, financial and otherwise, loss of services, loss of nurture, guidance, care, instruction for the decedent's children, loss of inheritance, mental pain and anguish, funeral, burial expenses, non-economic damages for the gross negligence of defendants allowed by law, PH's pre-death pain and suffering and fear of impending death, punitive damages for the gross negligence of one or more of defendants to the extent allowed by law, and any and all other damages recoverable by law. All said injuries and damages in an extent not now precisely known are in excess of 50 million United States dollars. Jury demand: plaintiff Richard Ortoli requests a trial by jury on all issues raised herein. We pray for relief. Here's the concluding magic words. Wherefore, Richard Ortoli, as administrator CTA of the estate of Paul-Henri Louis-Emile Nargeolet, prays for the following relief: actual damages and costs incurred herein, pre-judgment interest at the maximum rate allowed by law, post-judgment interest at the maximum rate allowed by law, and any further relief to which plaintiff may be justly entitled. Amen. So there we go. That, ladies and gentlemen, is the lawsuit for $50 million filed by the estate of Nargeolet against OceanGate, Russia's estate, the guy that designed the thing, the guys that made the plexiglass window, the guys that did everything. So this is the $50 million lawsuit. This is the shot fired across the bow. This is what starts the war. It's going to be long and drawn out because none of those people are going to want to pay anything. And the question really is raised is, do they have any money to pay? So, there's so much that will not and cannot be known for a great long time, but the first of the lawsuits has been filed 1 year and 2 months after the incident. Well, I guess it was actually about 5 weeks. It was filed about a week ago. Guido Sarducci. Wow, there's a throwback. You're old, burning sensation. So am I. Can the other families get added to this? They will most likely be filing their own lawsuits. I would guess. I would guess they would be filing their own lawsuits in due course. This was the first big one. This involved the superstar explorer Nargeolet, so it'll get the most attention. I'm sure once the Pakistani guy, his family files their lawsuit, that'll get a little bit of attention. It's interesting that I was asked just a couple of weeks ago, are there any updates in this case? And I said no. And then immediately after that, the Coast Guard announces that they're going to be doing the live hearings, and then this lawsuit got filed. So again, to reiterate that, I mean, we'll follow this as closely as we can. Like this is going to be years of nothing. But within the next month or so, we should be seeing a response. If I can get a copy of the response, I'll be sure to go over that. But as I mentioned, starting on September 16th, Monday, September 16th, the Coast Guard is going to be live streaming public hearings on the implosion of the Titan, and I will be streaming those as well, as much as I can live. Otherwise, we'll kind of do it like we do with the court thing. We'll catch up on one day and go into the next day. 79 Cecilia says, what about the waivers? Oh, there's a whole big section about waivers in the middle. Oh, that was Joe Choi. Sorry, Joe Choi. I meant to click up here. What about the waivers? It's a good, solid waiver, but their arguments are he didn't tell us all of the risks, and he was grossly negligent and can't just get away from it. Which, like, go back a while. You'll have to go back into it and rewatch. But there was the section about the waivers. It's a good waiver. It's very basic, very simple, 4 sentences long, mentions they could die 3 times in 4 sentences, and mentions that ain't nobody tested or inspected or certified this thing, and you might die. So it's a good, solid waiver, as basic as it is. But again, they're saying that it didn't disclose all of the risks, all of the very important risks, and he acted grossly negligent and shouldn't be allowed to rely on the waiver. And that's it in a nutshell. Starkey, you have a 10-hour tattoo session on the 17th. Youch. That's some impressive numbers there. Yoink. All right, so we will be doing that on the 16th, beginning with the 16th, and going through that week most likely. Gosh, I think that's just about all we got. We got 456 people here and 467 likes. How did our like and subscribe poll end today? The question for the like and we have 600 votes, so 130 more votes than we have likes. All right, what is wrong with the OceanGate case? That was the question that was posed to you today. What is wrong with the OceanGate case? 14% of you said it was a titanic waste of life. Wow, you sleep through tattoos, Starkey? Youch. I'm kind of jealous there. 14% of you said it was a titanic waste of life. 26% of you said there was no cannibalism. That was the problem with the case. 29% of you said it was a crushing failure. And 30% say lies and bad construction. And Heather Sparrow, member for 18 months, dropping us the thank you, Jeff, for powering through this. I'm currently replacing my Jeep steering wheel with an Atari joystick. Well, good luck. Just don't take it into a lake or anything. Oh, and Heather also said Jeff is my favorite YouTuber. His personality reminds me of my brother. Oh, well, thank you very much for that. That's incredibly kind of you. We're going to drop the strawberry cam here so I can talk to you very briefly before we head on out. Good night, Straubs. Say goodbye to everybody, Strawberry. You just don't care, do you? All right. Well, we're gonna wrap up this edition of Maritime Monday, and we likely will not have a Maritime Monday next week for reasons. The reasons being, like, tomorrow. Let me find somewhere to send us while I'm talking here. Tomorrow we will be looking at the Sarah Boone hearing from last Friday. She had a little bit of a hearing. I want to watch that. We'll be doing that on Friday. Tuesday. Wednesday, I'm not sure yet what we're going to be talking about. Probably something. Thursday will be our retro trial, the Donald Hartung trial. We're coming to the end. We had a Wiccan high priest testify last week. So we've started the defense's case. I believe the defense may rest either this Thursday or next Thursday. And let's see, I'm looking through here still. And then Friday will be the unexplained with our very own Flux and Danny on direct. If she can be here. She's got a scheduling conflict. We're hopefully she'll be able to somehow get that taken care of, because we will be having a special guest, a friend of mine who is a ghost hunter and a Bigfoot hunter, and she's recently discovered that she might be a medium. So we'll be discussing the unexplained with her. So that'll be on Friday evening U.S. time, starting at 8 p.m. Eastern. All right, who are we going to redirect to, people? Who are we going to redirect to? Legal Mindset, Cat Not Williams. Cat Not Williams is doing day 109 of the day 109 of the YSL trial. I think we'll go to Cat Not Williams. Make sure you give Cat Not Williams a super special thanks and a hi. All right, people. And keep it on your calendar. A week from this coming Friday will be the new and revised F-It Friday. Same great panel of guests, just less drinking involved. There'll still be some. We're gonna make the F-It Friday Ferris wheel of fickle fortune, where we will basically stealing the idea from Nick Starro. His wheel of misfortune or whatever it's called. We'll put about 20 different things, and every $100 that comes in, we'll spin the wheel and we'll do whatever it says. There'll be some rewards, there'll be some punishments, there'll be some other stuff. Well, I have to figure out what to do. So that'll be a week from this Friday, the new revamped F-It Friday. And Corn Pup says, I guess the jury isn't calling it quits in the Young Thug. I don't have any idea, but hopefully Cat Not Williams will be able to sort it out for you and tell you what's going on. So, all right, everybody, that's it. Thank you for joining me for another Maritime Monday. Join me tomorrow for Sarah Boone's hearing, and I will see you then. You guys rock. Mods, thank you so much. Thank you so much for unleashing the emotional support Potato Pig Dog Cam supporters through your super chats, monthly memberships, gifted memberships, all that other fun stuff. And thank you for everybody that's just here in the chat, hanging out, keeping us all comfortable, keeping us all company, keeping us all laughing. You guys are great. I will see you all tomorrow. Until then, make sure you enjoy your legal vices. Bye now.